Moving on, speaking at the inauguration of Andhra Pradesh Judicial Academy, Chief Justice of India CJI Chandrachud reiterated his stance on perhaps the most fundamental rule of criminal justice system, bail but not jail. He raised his concerns over the sheer magnitude of under-trial suffering in prisons and how it was deprivation of liberty for a single day in a day too many. He also claimed that there was a sense of fear amongst the courts on how the grant of anticipatory bail or normal bail will be perceived at the higher level. He went on to add that the trial court judges have pulled up for grant of bail in certain high courts. The performance of the judges has been analysed on the basis of conviction rate. Chandrachud also revealed that he had called upon the Chief Justices to ensure that such practices are done with as per National Judicial Data Grind or over NGDT. Over 63 lakh cases are considered to be delayed due to the non-availability of the counsel, and over 14 lakh cases are delayed because they await some kind of document or record. Speaking about district courts, he asserted that Section 338 of the CPC and Section 439 must not be meaningless, mechanical, procedural remedies which are perceived at the grassroots level in the district judiciary only to get a rejection and then move to a higher court.
It appears that in some cases, I mean, no, not all, like certain cases, for example, be the Sanjay Raut matter or some matters where there are financial offences involved, then of course one needs to certainly, custodial interrogation may be required. But of course, the objective of bail is to assist the doctrine of custodial interrogation. However, we have seen innumerable cases. For example, there are quite a few cases in which I myself have appeared, like in the case of Mangle and others, where despite, because like the biggest concern is that, in some cases, bail is not granted even where the matter appears to be a complete, abuse of process of law. I do feel that the doctrine of bail, not jail, is a very time-honored doctrine. And it has contemporary relevance because the court has to essentially see whether the person will interfere with the investigation or not.